Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense here on YouTube. Today we're going to talk about frivolous lawsuits. Well, with one exception. We're not going to talk about plaintiffs who sue for things like crunchy versus creamy peanut butter in prison. We're going to talk about frivolous defenses. I'll have more on that in just a second. Several years ago, our office brought a claim for medical negligence against a cardiologist who had inserted a pacemaker and had placed the leads for the pacemaker incorrectly. In a two-chamber pacemaker, one set of leads paces the atrium and one set paces the ventricles. And if you pace them out of order, and the heart normally works by the atrium pumping blood down into the ventricle and then the ventricle contracting and shooting that blood out to the rest of the body. But if you reverse the leads such that the ventricle collapses and then the atrium collapses, pretty much all the blood does is go back and forth, and it results in something called congestive heart failure, which is generally not very good for anybody. Well, when the defense in that case presented its defense, it was a causation defense. In other words, they didn't dispute the fact that the leads were positioned in the wrong place because, for the most part, that was impossible to deny based on the pacemaker tracings. However, what they said killed the man was an unknown viral illness. Now, they couldn't prove it because they didn't do an autopsy. And even if they had done an autopsy, they probably couldn't have cultured out the virus. So it was more or less the perfect defense because they didn't have to prove it. They just had to raise a doubt that we were wrong. And more importantly, they could rely on that defense to help reduce the amount of the settlement at some point in time. Well, there is an ethical rule that requires an attorney to assert claims and defenses that are based in fact and law. And it is important to remember that while there are frivolous lawsuits, for example, prison lawsuits where prisoners will claim that their rights have been violated by virtue of only being able to get creamy peanut butter when they wanted crunchy, or vice versa. Or their bananas had too many spots on them, right? Those are the kinds of frivolous lawsuits, what lawyers call recreational litigation, that truly are frivolous and shouldn't be in courts. But there are a lot of defenses that shouldn't be in court as well. And unfortunately, a lot of those defenses are just ignored by the courts and the judges that hear them. Instead of being rightly called out with a "are you kidding me" kind of thing.
Are you kidding me?
So, what happens when somebody makes a frivolous defense? Well, there are two things that your lawyer can do in that situation. One, he can disprove the frivolous defense, which in most cases he will. And two, he can, in some instances, file a bar complaint under Rule 3.4. I misspoke. It's actually Rule 3.1 on meritorious claims and contentions. As you can see, it's available on the internet and you can read it if you'd like. It doesn't apply in all jurisdictions. California, for example, has not adopted the ABA Code of Professional Responsibility, the rules of professional conduct. But in most states, that kind of bar complaint can be made. And when it is made, then usually the bar will at least do a minimal investigation to determine whether or not those claims or defenses are actually meritorious, whether they were supported by any set of facts, and whether they had any chance of ever really prevailing. Now, this is not a panacea. It's not something that's going to stop somebody from making these allegations. But it is at least some measure of vindication when the bar comes back and says, hey, you shouldn't have done that. Now, that doesn't mean the lawyer's going to get disbarred. Usually all that happens in those situations is he'll get a letter of reprimand saying, hey, bad dog, no biscuit. But it is at least some kind of indication for those kinds of frivolous issues that arise. Now, if you and your attorney believe that you have that kind of situation, as I said, there are avenues within the law that you can bring that up. But you should not ever use that as a lever to try and force settlement. A lawyer is prohibited from saying to the other side, I won't file a bar complaint if you will drop this, if you will settle this lawsuit. He can't do that because it is basically extortion. And you can't ask him to do that because he won't do that. I think that's important for people to understand. A lot of times people think that that's just a really good lever to apply against the other side when in fact it is not. And you wouldn't want it applied to you if you had overstated some claim that you then could not later back up in court. So that is the story of what happens when somebody makes a frivolous defense. It's definitely not a huge deal, and usually it doesn't result even in a significant bar investigation. But it at least fires a warning shot across the bow of an ethically challenged attorney who writes a pleading that contains that kind of drivel. Lawyers are charged with a trust that they will do the right thing in the right circumstance. That means that they need to be careful and judicious about not only what claims they bring on behalf of the plaintiff, but what defenses they assert on behalf of the defendant. Now, that doesn't mean in any way that some defendants should not get the full measure of protection of the law, because every case has some defensible element to it. But it does mean that you can't fudge on the facts and the law in order to assert a defense that doesn't really exist. So if you found this interesting or helpful, I would really appreciate it if you'd smash that like button for me. And if you haven't already, please go over here and subscribe to our channel and touch that notification bell so you can get a notification every time we release a video on this channel. Thank you so much for watching. Have a terrific day. I'll catch you next time.